Hello everyone, welcome back to Will's Trust and More. And Eileen, thank you again for coming back and doing the show with us and sharing with the viewers a lot of information that people really don't even think of or know of. And in particular, the topic today is talking about wills and when you should be creating a will. And I do have a question, and we're going to start out with, what if mom and dad just keep home in their names and have a joint tenancy? Do they need a will, and what kind of will should they have?
Okay, the family home. That is something that almost everyone has. Not everyone has a complicated family situation, not everyone has complicated assets, but overwhelmingly our clients have a family home, and by the time they're thinking about these documents in retirement, it's often paid for. And the family home is often the asset that will trigger a probate. Sometimes we have parents who have done their beneficiary designations, they have payable on deaths, and the only thing that isn't wrapped up after death is the family home. So it's often the thing that will trigger a probate. Now, if we have a simple will, that's fine, that's good, better than nothing, and says the home goes to the children, that will still has to be probated. So we're going to have a court process that many parents don't realize, and is only going to happen because of the family home.
Now, is there a probate process even if it's transferred on death?
Well, we're going to talk about the various ways that you can transfer it, and our aim is to avoid probate. And what parents used to do to avoid the probate, for those who were aware that a will wasn't enough, was put the children or a particular child on the deed with them, made them a joint tenant. Now that may very well have avoided probate, but it was full of unintended consequences, the need for that child to be available if they wanted to sell it, if that child was going through divorce. There were just many unintended consequences. So we can do much better than that. The simple will that triggers a probate or putting a child on there. We have several options, and we often do talk about complicated issues. Today we're just going to talk about that family home, and we're going to talk about 4 tools that we have at our disposal to prevent the home going through probate.
Okay, how about starting with tool number 1?
Tool number 1 is a relatively new, exciting for us tool in our toolbox, and it's called a transfer on death instrument. It's brand new, January 1st, 2012. We used it cautiously the first couple of years because when there is a new law, there's often teething issues, and to be honest, we have to wait for someone who transferred that property to pass to see how smoothly it goes, and are there going to be some unintended consequences there. They've been working very well, so now we're using these documents very comfortably. It's a bare bones way to transfer the family home to the children or whomever it's going without probate. It's a transfer on death instrument, so it's a lot like a deed, but we're not calling it a deed because it's not an immediate transfer. We draft a document whereby the homeowner says upon the death whom this property goes to, and it gets recorded, and now it's out there on public record. And that's probably the downside, the disadvantage of using this very bare bones document, that you're wearing your heart now on your sleeve on public record. Anyone can go to that record now and find out who you are leaving your assets to. Even a will doesn't become public record until after death. So that's probably the downside with it. It's inexpensive, and they're working very well. Now, another disadvantage with that document is that you really are somewhat limited in what you can do with the language. You can say whom you want it to go. You can say if they predecease you, who it goes to after that, but no special instructions, no John shall only take if he's still married to Mary, or Mary shall only take if she's still in her sobriety program. There are things we can do within the privacy of a trust that belong in the privacy of a trust that we cannot do with that instrument. So it's inexpensive, it's bare bones, it's public, but it's a new tool to avoid probate that we didn't have before. So that's number 1.
Okay. Before we go any further, does value of the assets have any play into this?
Well, yes, it does, because when we're determining what estate plan someone will do, the value of the assets is a factor in addition to the complication, the titling, the family situation. So When we have very valuable assets or a complex family situation or both, and we're talking about blending, special needs, all of those kind of things, we're probably going to jump to number 4, which is a living trust. And then we put the family home in there with everything else, with the vacation home, with the out-of-state property, with all the needs and trusts and general and special that we're going to put in there. So the value of the assets would determine part of this equation, but if it's just the family home on its own, we may never need to go to that revocable living trust that we have talked about here often. We may be able to do with one of these simpler products, and sometimes clients just want simple, and sometimes simple will do. You know, the simplest, most inexpensive, easiest understood way to achieve our clients' goals and wishes is our ultimate aim.
Okay, the next step, tool number 2.
Okay, so transfer and death, if we don't want a public record or we want a little bit more flexibility with the language, we can move to bank trust. And these have been around in Illinois for quite some time. They're fairly well understood. We do have people who are now in their 80s and 90s who have had a bank trust for many years.
Are there advantages, and I'm sure there are disadvantages, maybe?
To using a bank trust?
Yeah.
Absolutely. The main advantage, well, one, they're less expensive than some of the other types of trust. I mean, they're relatively simple to set up. You'll use a lawyer for the trust agreement and the deed. The bank will become the trustee. The trust agreement will say what happens afterwards. There are small fees to set them up, but nothing even close to probate. There is a disadvantage in that you have an ongoing bank fee every year. Not much, $75, $100, $125, but it's still an ongoing fee that you might want not to have. There's a real advantage to these bank trusts that no other trust that I offers, and that is privacy of ownership. So if you get a trust with Chicago Title or one of the local banks, it'll be trust number 123 ABC with the name of the bank, and that's it for the public record. So especially if you purchase your property into one of these trusts, or even if you transfer. Now, transferring it in, there's a very clear record of who transferred the property into this trust. Is not, you know, it doesn't offer the same privacy. But the privacy of ownership, especially if someone is doing a search for assets or someone has nefarious purposes in mind, that really is one of the nice advantages, and some people will use that simple form of trust for several properties just for that reason. But again, while we don't have the public record aspect, we still have limitations on what we can do with the fund, with the instructions. So the bank as trustee for $100 a year is not going to get fancy. They're not going to manage a property. They're not going to determine that John can live there for 6 months after the parent's death as long as he pays the bills or anything like that. It again is fairly bare bones, but at least it's private, and there's only so much you can do with that. But just like the transfer and death instrument, relatively inexpensive, avoids probate, and can get the job done.
Okay, so you go to the bank where your mortgage is at, for example, you want a trust. Is the bank the trustee, or can you be the trustee?
The bank is the trustee there, and they will not even draft these documents for me because they don't want the liability of that legal language, and if there are errors made there, that's not their job, and it's not what they want to do, and it's not what being trustee means. So an attorney will draft the trust document itself, and then the bank will be the trustee. Now, that is what you pay that additional $100 per year for, but you really don't need the bank to be your trustee. You can be your own trustee, and if you want to be your own trustee, then you move to either the third or fourth document that we've talked about, trust that we've talked about. And if we want to be your own trustee, but we still want to keep it as simple as possible, you can do a stand-alone residential trust. Very similar to the bank trust, except there's 2 major advantages. You get to be the trustee, you can determine who will be the trustee after you, and now you get to tailor the proceeds, the property exactly as you want, because you're naming the trustee, you're going to be the trustee to begin with. So you can determine if somebody gets to live in the property. You can determine if someone has special needs, that their portion will go to a special needs trust for them. You can put conditions and time limits on distribution. So you get to do all of that with your own trust. More expensive to set up, still avoids probate, but no ongoing fee. The advantage of being your own trustee, just don't lose your trust document, because if the bank's the trustee, at least we know that they're always going to have the document. You have to take care of your own. But ultimately, we do have clients who lose the original documents, and they can be restated or they can be certified. It rarely means the death of the trust. if you lose a trust document. But our clients, I have often found, are pretty good. In fact, they usually have all their original documents for the last 30 years. So that's rarely a problem, but certainly one of the considerations.
Okay, before we go in any further about trusts and living trusts, they're irrevocable is what I want to go on to next. But can you explain to the viewers, when you say probate, what does that mean to the viewer? What is the process that this goes through a court? A judge looks at it, makes a decision. What is that process?
Okay, and viewers, we have talked about probate many times, but I'll tell you it's worth repeating, because when clients come to us, that's what they want to avoid. No one wants their estate going through probate. What it means, if we have no estate plan at all, no will, or just a simple will, if there's a large asset like a family home that has to be transferred to beneficiaries in that will is going to have to be proven. The word probate actually means proof. So the judge has to approve that that is a genuine will, admitted to probate. The administrator has to be approved by the court, and then whether it's supervised or unsupervised will determine to what extent the judge continues throughout the process. It is invasive and it is expensive, and if there's no family disharmony in any other way, you know, it adds 6 to 9 months, often longer, to the well, we have to keep it open for 6 months. Because in Illinois, and here's not just the cost of probate, one of the disadvantages of it is that when an asset is in your name only, no joint tenant, no beneficiary, no trust, it's subject to claims.
Yes.
So part of the process is that we have to go to the law bulletin and say, hey, this person died, their estate is going through probate, which is a trigger that there is a large asset, otherwise it would be passing some other way, and they get 6 months to come forward. So it's public, so that too is a good reason to avoid it. Not that many of our clients have anything to hide or claims that they don't want to pay, but it truly does provide a forum for possible trouble that there's absolutely no need for. I do probate all the time because, Ron, the statistics from when we started this program a couple of years ago haven't changed much. They're a little better, but we're still over 50% of people who do no planning. So I'm probably twice a month in the Daily Center on several of our probate cases. So that law, that practice is not going away anytime soon, but it's completely avoidable. And if I do the estate plan for the client, and they comply fully, because of course, if we said often, if we do a trust that does have to be updated, we'll never be in that court. We'll just never be in that court, and it cuts out expense, costs, fees, the public nature, and the time.
Yeah,
absolutely.
Good explanation. I follow you all the way. I hope the viewers do as well. Revocable living trust. When do you think about doing this? Okay,
that's our biggie. And that's the fourth way that you can transfer the family home without it going through probate. A living trust is a little bit more planning than some clients want. If we need a living trust, as we said a little bit earlier, because of the assets, the family situation, and we're going to create it anyhow because this client's family situation and assets call for it, then that's the trust that the home's going into. We would rarely do a revocable living trust and keep an old bank trust or do anything separate unless there was credit reasons for doing that. But if we have other reasons to create the revocable living trust, then we don't need any other vehicle for the home. The home is going to go right in there in the treasure chest with whatever assets we need to get in there, either in the trust or the trust the beneficiary, to make sure the client's estate plan works for them the way that we intend it to.
Okay. Anything else you want to add to this? Any other considerations that you should be?
With trust planning for the family home or any planning, just the follow-through, the follow-up, just getting the job done, and we highly commend anyone who gets it done because it's as much a benefit to them in their lifetime because of the peace of mind it offers. But in addition to get it done, if there's any follow-up, like calling your homeowner's insurance carrier, getting the trust named as an additional insured, if you take the home out to refinance, you do not always have to take your home out of a trust to refinance. It depends entirely on the financial company who's doing it. But if they do ask you to take it out, get it back in again. If you move from this home to another home, make sure that you transfer the new property into the trust. So it's just that little bit of follow-up, remembering that you have a trust, maintaining it. If you have a bank trust, certainly to pay your fee, because if you don't, one day a deed's going to pop up on your doorstep because they'll have deeded the property out of the trust for non-payment, and now suddenly, it's a wild card because lay people don't even know to go and record that deed. The bank doesn't record it. They're not going to spend any more money on an account that isn't being paid for. So that's the follow-up is the most important thing, Ron. And as you know, we are going to be taking a summer break. I am not going to be here in the month of August. We'll start again in September with other subjects. But a thought that just occurred to me this morning as I was preparing for the program. Estate planning is many things, but it's never dull. And I take my continuing legal education credits always, which we lawyers have to take every year in estate planning. And I attended a seminar recently where we were talking about ultra high net worth. Now, we deal with high net worth all the time, and we've talked about it many times in the show. This was in the arena of private islands.
Oh my
planes,
gosh, I can relate to it.
Families with not just tens but maybe hundreds of millions who have antiquities in their assets. The grandfather who left the Monet to one grandchild, the Degas to another, and now there's millions of dollars difference in the value, and the family are fighting about it. It's just a fascinating subject. And no matter what we have, we all need planning. And it may be difficult, it may be complex, but it's never dull.
It's and you're very excited about talking about it.
I
Just
love
look at
it.
the exuberance that you have.
I love it.
Okay, well, for those people that have some questions, please call Eileen Kerlin Walsh. Her number's at the bottom of the screen, her address is, she's a local attorney in Worth, Illinois. So we encourage you, if you have a question, you do not have an attorney, you do have no guidance whatsoever, give her a call. She'll answer any question. Am I right?
Absolutely. Anytime. Delighted to do the program. Our clients do call. Our viewers do call. They have questions.
Good.
They have needs. So I'm delighted to be here. I love to talk about this subject, and we love to hear from the viewers. So
very good.
Call
you
us
have
anytime.
a great vacation.
Thank you.
I know you're going quite a distance, and we'd like to hear a little bit about when you come back.
Absolutely. Thank you, Ron.
Okay.
Thanks again.
Thank you, viewers. I hope this has helped you, and if it hasn't, give Eileen a call, and we will see you next time very soon.